My name is Lukas Vanhonnaeker. I'm an assistant professor at the law faculty of the University of Montreal, and I have the pleasure and the honor of being the moderator for our third panel. So this morning we had a panel on the state of ODR in Canada. We had a second panel on ODR on the court, and now we have our third panel on ODR and other public bodies. Now I'll be very brief so that I leave time for our panelists, and we are very lucky to have three experts in the field of ODR that are here to talk to us about ODR and other public bodies.
Do you mind talking in
the mic? Sure, yeah. Is it open? Yeah. Okay, perfect. Three experts in the field of ODR. We have Lora Bansley, we have Ilona Bois-Drivet, as well as Professor Katsh. Now, they will introduce themselves, so that I won't do that. I just wanted to thank them for being here with us. As you, I'm looking forward to the presentations. Now, before giving the floor to Lora, I just wanted to suggest to leave our questions and comments for the very end of the presentation. So if you have any questions or comments, write them down and keep them for the very end after the three presentations took place. It's going to be easier, I think, to manage time as well. So without further ado, Ms. Bansley, you have the floor.
Thank you. Good afternoon. It's a pleasure to be here with you and share with you a little bit about my experience of implementing ODR in Saskatchewan and the good work that was done there in the past 4 years. I'm going to discuss a little bit of selecting a project in a jurisdiction for your very first ODR implementation based on my experience and lessons learned. And then I'm going to share with you about the Consumer Disputes Project that was implemented in March of 2023. Ilona worked on that project with me as well, so she can help me answer any questions if I am unable. So Saskatchewan had been monitoring ODR implementations in Canada for quite some time and decided it wanted to implement ODR in our province. We'd obviously had seen a lot of CRT and had them come speak to our province. So I was hired to help bring ODR to Saskatchewan. And so the first decision was what dispute type to start with and select for our first projects. I first did a jurisdictional scan of the various ODR projects in Canada and other countries and looked at the case studies and the successes. And then I did an assessment of the most suitable project to start with in our province. And I'm going to share with you just some of the lessons I learned for consideration, although I recognize I sort of feel like I'm speaking to a room of the converted, but it is kind of struck me in listening to everyone and everyone's passion for ODR that when you're trying to do a project in your province for the first time, of how difficult it actually still is, given the number of implementations we have seen around the world. So the first is change readiness of a program area. And so that was looking at, are they interested and motivated to change or transform their current process? I always said when I was looking for the coalition of the willing, and with the Consumer Disputes Project, it very much was that. They were a willing partner that were really anxious to transform and really had bought into improving their process. And so having a willing partner obviously is extremely helpful. And then considering if there is resistance to a change, for some program areas, they've had change saturation. And I also found certain groups that had experienced a lot of change or a lot of transformation projects that had failed. It doesn't mean that you can't still do an ODR project, but it just would say that it definitely can take longer to get them through the change curve if that's something that they've experienced. Next is the need. So is there an area that's experiencing a crisis or pain? For example, have the volume of disputes significantly increased, or are they experiencing backlogs? Sometimes having a bit of a crisis or a need in their business processes can help get buy-in to a transformation or a change. Even if they're not super eager for that change, they know that the way they're doing it today is not working for them, and that they need to do something different. And finally, complexity. The first area of complexity, obviously, is legislative changes. Are legislative changes required to implement ODR and to implement the process changes? And sometimes with legislation changes, obviously, timelines can be a bit out of your control, and then there's more individuals. In the Consumer Disputes Project I'm going to be speaking on, they did not have to implement any legislative changes. It was just simply process and policy changes. The other factor is, are there numerous players and stakeholders in the end-to-end process? The more stakeholders involved and the areas impacted by the change can definitely lead to less alignment and can make decisions in the project more complicated. In my experience in public bodies where there's a single decision maker for the whole process that can make decisions can definitely make it easier. In contrast, a court ODR project, we also had a court project that was not implemented yet in Saskatchewan, and the court processes obviously have a number of players that often have responsibility for their piece of the process. So for example, in traffic court project, we had law enforcement, court operations, prosecutions, judges, and fine options. And this definitely can slow down decision making and impact timelines when you have so many different stakeholders, each with a piece in the end-to-end process and needing to get alignment on all those players to make decisions. And then the final consideration in complexity is obviously integrations with legacy technology and existing systems. When you're implementing ODR, obviously, if there is a system that it needs to integrate with, you know, it has that legacy system made integrations before? Does it have the capability? And also the other, I guess, lesson learned from Saskatchewan was the impact of the legacy system and what's going on with it, and any projects or changes it might be going through that are outside of the project team's control as well that may impact project timelines. I'd like to now turn to the Consumer Dispute ODR project that was implemented recently in Saskatchewan. So the Ministry of Justice was where I was situated, had a team that partnered with a Crown corporation in our province that had the Consumer Protection Division that was responsible for administering consumer protection legislation in our province for all transactions involving the purchase of a good or service for personal or household or family purpose. And we worked on the project with KPMG and Group Cyberjustice for the technology. And we also had resources from our ministry in Saskatchewan responsible for IT governance and IT project standards and for our infrastructure. So what was the current state, or what problems were we trying to solve with the consumer disputes in our province? So consumers with a dispute have a number of options for resolving disputes in Saskatchewan. Prior to the implementation of this project, they could phone a number at the protection branch and discuss the issue, and if it warranted further, they could file a complaint against the business. Staff would then investigate the dispute and act as an intermediary between the parties to help achieve a resolution. This option would often take considerable time with managing schedules for the parties to connect for phone calls or for meetings, and often would take several rounds of communication. Consumers often would get frustrated with how long the process was taking, and often would give up. The Consumer Protection Division in Saskatchewan typically receives about 5,000 to 7,000 inquiries a year, and they had about 500 formal complaints filed each year. Obviously, consumers also can have the option of initiating court proceedings depending on the dollar amount of the dispute. The small claims limit in Saskatchewan is 30,000, and anything above that would be initiated in the Court of King's Bench. So the objective of the Consumer Disputes Project was to transform consumer dispute resolution to make it more effective, simpler, and faster. And the project outcomes were that consumers and businesses would see reduced time and money spent on disputes with a greater success rate of resolution, increase consumer protection and strengthen consumer confidence, and to create efficiencies for the Consumer Protection Division staff to create greater capacity to serve consumers and businesses in our province, and also to fulfill their mission, which is to promote confidence by regulating and educating the Saskatchewan marketplace. The project implemented technology that had two components to it. One, the legal guided pathway, which was branded consumer rights, and second, an online dispute resolution suite. So the legal guided pathway is similar to what CRT has for Solution Explorer. Often the first barrier parties to a consumer good or service dispute experience is they often don't know at the outset what their legal rights and their obligations are. This information is difficult for many businesses and consumers to find or understand, and often disputes are prolonged due to misconceptions. The Consumer Rights Pathway provides information to consumers and business specific to their area of dispute. Often I find legal information websites or providers often have PDFs or lengthy documents that you're scrolling or clicking through. And often the consumer or the business is in the driver's seat of having to understand their legal problem and issue and understand which law in that information applies to them to determine what is relevant to their dispute. In contrast, the legal guided pathway uses intelligent questions to facilitate an efficient guided process to get the information that they're looking for that is relevant to their dispute. And the ODR guides the consumer and business through a system-led online party-to-party negotiation, provides a platform for facilitated resolution by a Consumer Protection Division staff, and then it can lead to online mediation with a trained mediator. And then documents of resolution reached through the negotiation or the mediation phase. So a little bit about the project timeline in our province. So it started in January of 2022 with a requirements validation and solution design phase. We then began development in August of 2022 until January of 2023. And then testing was conducted in February and it was implemented in March of 23. Before I go into screenshots of the actual solution implemented, just to give you a little bit of a high-level overview of the steps a consumer would go through. So they would start with the consumer rights pathway to sort of inform them, empower themselves, and educate. They then attempt to resolve with the business, and I'm going to show you some of the options we have for templates for them to send a letter or an email. Then they would initiate the dispute where they would describe their issue and the resolution sought. They then negotiate with the business in just the party-to-party negotiation process. If it doesn't settle then, a CPD staff then facilitates resolution. And finally, if it still hasn't resolved, then there is a facilitated mediation, again, through the platform. I would like to mention that this is a voluntary consent-based process. There is no binding decision-making or adjudication in the process, which initially was why there was a part of me that didn't want to start with consumer protection in Saskatchewan, because I was really anxious to have something sort of a full tribunal like CRT with online adjudication. But anyways, it doesn't mean it's still not beneficial and with this process. Staff and mediators use what they call moral suasion to help parties reach an agreement. And then, as I said, if they do not settle, they still can initiate legal proceedings in our province. And hopefully these might be hard to see, but this is actually screenshots from the system. So as I indicated, a consumer would start with the consumer rights pathway to inform themselves. There's also pathways for businesses that discuss their obligations. So one of the first things with entering the system is you select whether you're a consumer or whether you're a business. Next, you would select the type of issue. So for example, if you clicked on prepaid purchase card, or another example would be a vehicle dealer. And then it provides the legal information relevant to them. And then from there, it suggests that they resolve with the business. And one of the things I often find that when someone's accessing, again, legal information, it'll tell them their legal rights, and it'll say, attempt to resolve with the party. And often it's like, okay, but how? Like, that's the what, but then how do I resolve it? And I think a lot of times we forget that a lot of people don't have the words and the language or what to put in a letter or what to put in an email. And so what you can see there is that we have the options of a template that actually, based on what they've described that their issue is, it creates a template, either an email, a Word, or a PDF, where they just fill in and then can send it to the business. To file a dispute, users log into a single sign-on service for the Government of Saskatchewan and link their service. They then can either search for a business, and if they aren't in the system, then they can manually enter the business. They describe the problem with, what good or service it was, how much did it cost. They describe what interaction they've already had with the business trying to resolve it, and what is the problem or dispute they're experiencing. And then next, they provide what resolution they're seeking, whether it's return of the good or repair of it. And then you can see the business can accept the consumer's proposal, or the business can make a counter proposal. And when both parties agree the resolution, a settlement agreement is created for the parties to then agree and sign. This is showing a little bit of the back end. There's a queue that first, when a dispute comes in, it is screened to make sure that it is within the mandate of the Consumer Protection Division. And then if the parties in the negotiation aren't successful, a facilitator is then assigned. And also a party can report an abuse fund. So there is when they're in the process, can report abuse, and then that would go into someone at CPT. When a facilitator is signed, they can review the information, and then they join the exchange between the parties. This is a message center where the parties can exchange messages, as well as with the mediator or the facilitator. And one change that was made after implementation is that a business now cannot just reject a proposal and close the file. They have to explain and provide a reason why they're not counter-proposing before a file can be closed. So some of the statistics is that there's been over 1,000 individuals have gone through the consumer pathways. There's 138 cases in the system. It was implemented towards the end of March, but it really wasn't promoted until July. 56 have closed, 47 at the negotiation stage, and 9 at the facilitation, which is kind of opposite than the CRTs right now, and it'll be interesting to see if that lasts. I think one of the differences between consumer protection and a lot of the disputes for the CRT is that you have businesses that have somebody responsible and sort of do it and get familiar, whereas in the CRT you usually have two parties that it's their first time and they don't kind of have that experience built up. So we hope to continue to see more settling at the negotiation phase. And so far, we've had none go through the mediation. So in conclusion, this initiative has revolutionized how consumers and businesses manage disputes. It has streamlined dispute resolution to be more effective, simple, and fast. And the project was recently selected for an award for excellence in the public service for exemplary citizen service with the Deputy Minister, the Premier. So it's being recognized in our province now. Despite the fight to get ODR implemented in our province, it is being recognized. So thank you very much.
Hello everyone, my name is Ilona. I'm an analyst and a lawyer for a group cyberjustice, and today I'm going to discuss the feedback on the 2.0 version of the Parler platform with the Consumer Protection Agency, so l'Office de la protection du consommateur in Quebec. So we will discuss a little bit the background around the Parler OPC project, then discuss the highlights of the project through the sense of access to justice, and then we will discuss the objective of Parler OPC 2.0. So first, the background. So the Parler OPC platform was launched in 2016. Here, it was developed by the Cyberjustice Laboratory as a pilot project, and it's regarding the consumer disputes here in Quebec. The number of Canadian participating businesses, so there's 135 businesses right now participating in the platform. They are a department store, furniture and appliance, swimming pools dealers, vehicle dealers, and home renovation companies. So we can think about Rona, Home Depot, Brouet Martineau, Corbeil, so a lot of businesses here in Quebec that are participating on the platform. And the problem types are exclusively civil, and it's regarding product or service not delivered, delayed, not confirmed to the contract or as advertised, defective good, or not effective for a reasonable time. And within the platform, there are 20 accredited mediators that are members of the Quebec Bar that are participating in the mediation process if it goes there. So how does the process work? Parler OPC is not accessible by a search engine. So there's a triage first by an OPC agent. You have to call them and explain your problem to see if it's of a civil nature and if it involves a participating business. Then you can submit your case online through the Parler OPC platform. And so it's an e-filing process, a 5-step process where you can describe your problem through a form and then submit your first proposal. So the consumer is always the first to submit a proposal to try to saw a resolution. Then they enter the negotiation phase with the business directly, and they can discuss based on the first proposal. So through the same form, they can the business can accept the proposal or do a counter proposal, and they can have some discussion to provide context to the proposal in a message center. After 20 days, they can request mediation, and the mediator will try to help them have an agreement. So by mediation, only the mediator can submit a proposal, and both parties need to accept them to generate an agreement. So why did Parler OPC work? Well, it's low intensity, so it's easy to negotiate and to be able to understand your problem and be able to find an agreement with the business. It's state endorsed, so it's not a private ODR, it's with the protection agency. And the OPC did a lot of work to make some incentive to make sure business will participate. So, for example, if the business participate in the ODR, they will not, and they find a settlement with the consumer. They don't have they will not be. They don't have a plaint on the website, and it's also the mediation is also free for all consumer. And also, the platform is simple, accessible, and I will discuss this later, but there's a strong sense of access to justice for the consumers. Also, what made it work and what is interesting is that the Parler platform is a tool, and it helps people settle their dispute, but there's still human intervention. So a clerk is on the platform and make daily monitoring of the case. So there's different tools that were made to make sure that if after 5 days there's no action in a case, then a clerk can go in the case and make sure everything is going well. They can call the consumer to make sure their need are supported, or they can call the business to make sure that they will follow up on a specific case. So the project is also driven by user value. Since 2016, there were more than 8,000 cases settled on the platform, and the settlement rate is 76.6%. And to settle a case, it's around 20 days, and we say that 90% user satisfaction based on a user survey at the end of the process on the platform. And what is interesting also is that 65.9% of the cases are settled by negotiation. So negotiation is really the part of the process where parties can reach a settlement. And why? Because we guide the user through the process to make sure they can really express their problem. So the first step, like I was mentioning, during the e-filing process, they will describe their problem, and they have a form to help them target what they need to explain to the other parties. So they have the first opportunity to describe what happened and what is the problem here. Then they have a form to add the resolution sought. So, and this form will stay the same throughout the process, like I was mentioning. So if you're the business, the consumer, or the mediator, you all work with the same form, and this is based on this form that you will negotiate or mediate on a proposal. And there's always, also if you see, context to help the user understand what do we want from you here. So on their proposition here, it's regarding the proposition. So how can you fill out this form to make sure everything is there? And the blue box here is you're in the draft status, so what do you need to do in this particular status? So we try to make sure that they have support throughout the process to make sure they understand what is needed from them. And if a proposal is accepted by both parties, then it will generate an agreement with the forms that they fill out. So the problem description and the proposal that was accepted by the parties. So now the sense of access to justice. So it's a concept from social sciences that was taken up by the Honorable Jean-François Roberge that will be here after the panel 4. And it's to facilitate the understanding of the development in access to law and justice. And they conducted an online questionnaire to measure the quality and value that consumers attributed to the Parler platform. And so 654 respondents respond to this online questionnaire. And these were the consumers that completed the process on Parler with or without an agreement. And so the sense of access to justice index was based around 3 research questions. And the first one was, did consumers have access to justice? And they had to respond and give a measure of the quality of the process, the result, the adequacy, the support. And it would give an overall percentage of their sense of access to justice. And as we can see here, the sense of access to justice is pretty strong. It's in mediation and in negotiation, it's stable. People, the consumer, it's only the consumer, felt that the process was high quality, the result was efficient for them, and was like there was equity in the result. Even when there was no agreement, 57% were happy with the process and the experience. Then the other question, what are the benefit and value obtained by the consumer? And we can see that the consumer found that they were treating with respect, dignity, they were being heard, they were able to take part in an open discussion, they were able to justify themselves, and they had a discussion based on unbiased information. And the value of the process is that they obtain peace of mind, they avoid the risk of litigation when they settle, and they achieve a resolution without having economic cost. And the last question is, what are the factors that most influence consumer experience of justice? And this is relevant for the 2.0 platform that we just developed with the OPC, because it's the factor that have the greatest impact on the continuous improvement of parley. And in negotiation, here we see that it's important for the user to feel that they are being heard. They can get involved in the process. They can have an honest and open discussion, and they can justify their behavior. And how can the solution can help this process is by making sure that it's tailor-made to their needs, it's fair, and it provides a peace of mind for the consumers. It's pretty much the same with mediation. It's just that with mediation, the discussion will be conducted by the mediator, so the discussion that is respectful in good faith is more important in mediation. So based on this really important feedback, we went back with the OPC and we decided to do a 2.0 version of the OPC platform to improve the overall user experience and to make sure that it's still relevant and it can help them respond to the needs of the consumer still. So the first objective is more of a technological perspective, is to provide a new version of the platform that is scalable, robust, and highly configurable. And why? It's to avoid legacy system and to make sure that it's easily configurable for the OPC. So we provided new tools for them to update forms, to update notification content, to create new notification flow, and to add dashboard to track case. Why is this relevant? It's because it's to gain efficiency, and it's to allow the OPC to become autonomous and make sure that they can evolve with the needs of their user. And so, for example, if there's new category of consumer dispute, or if there needs to be changed in the forms, then they can already do it by themselves, and they can update throughout the process without having to go back to us, rethink the process, and make some updates. So it's really more efficient, and it can respond more efficiently to the needs of the consumers and the businesses. Then it's to prepare for the act to promote access to justice and increase its efficiency. So right now, the OPC is preparing to be able to obtain an accreditation for the PARL OPC mediation service. So we added the option to generate a summary package. So a summary package is a PDF document of what happened in the case that they can bring with them if they decide to go before a court. And they can now invite a third-party manufacturer, so with a mediator, so they can have a discussion. For example, Rowan Martineau and Whirlpool can have a discussion with the consumer and be held by the mediator to reach an agreement. And lastly, it's to improve the quality of the user experience to make sure that it's still tailor-made for the needs of the consumer, that it's still efficient, that they feel that they're being heard, that they have an open and honest discussion. And for that, we added contextual help, like I was showing you in the form. We added an option for the consumer to add a representative, so a family member or a friend to help them on the case. Integrated assistant request. so they can directly ask for help on the platform. That means that they don't have to go back to the OPC site to find who they call if they have some problem on the platform. We added the option to close the case at any time. So, and this way they can have the reason why they want to close the case, because sometimes it often happens that the case was closed because there was an agreement outside of the platform, so they can explain what happened and give some context. We also improved the counter-proposal system to prevent errors, and I will show you that later. And also, we realized, and I started as a clerk on the OPC platform, we realized that most of the time, when there was message in the message center, the consumer would receive notification, but they didn't know where to find a new message on the platform. So we decided to create a new UI experience to nudge the user when they have new messages, so we can make sure that they understand what is happening when they enter their case and where they need to provide an action on the platform. And we also decided to standardize the case tracking by the clerk. Like I was mentioning, as a clerk, when I was a clerk on the OPC, we had an Excel document. We needed to send email through our email inbox, and we have to see the cases on the platform. So we had 3 interfaces. Now we have 1 interface when we can do all of this action in one place. So here are some examples of user experience improvement we did. So this one is about the message center. So you see the V1, there's a message in the forum, but there's nothing indicating if there's one message or if there is any message. And now you can see, okay, there's 7 messages here. I need to go there and open this discussion to move the case forward. Then there's the proposal and counter proposal. So when you do a counter proposal in the V1, the form was filled out from the previous proposal. But there was a lot of errors because sometimes people forgot to remove an information, and it slowed down the process. So now you have the previous proposal on top, and you can start from there to add your counter proposal. And finally, it's the new centralized clerk interface, so it's more on the back end. And you can see on the left here, sorry, it's really small, but it's how you can track cases. So if there's been no action in 14 days, you can go and see and make some follow-ups on these cases. And if a case has been in negotiation for 30 days, then you have a list of cases in negotiation for 30 days, and you can do some follow-up directly in the case here. You can send an email, and you can add some notes to provide context of the last follow-up you did. So this new version will be launched by the end of October, and we will continue monitoring these enhancements to see how we can continue improving user experience and the need of consumer and adapt it to other platforms. So thank you, everyone.
My name is Ethan Katsh. I'm just this moment lost my voice. If you need to read about me, my bio is basically on the website, where you can ask Colin. He's my publicity person. I'm actually feeling good about ODR because I don't get into disputes very often, and this isn't really, it's more a problem than a dispute, but when I was coming here, I flew from Boston, and I quite stupidly left my raincoat at the screening area, and it took me about an hour before I realized, well, maybe there's a solution to this problem, and to my amazement, TSA, the I don't remember what TSA stands for. The people who do the screening of suitcases and whatever. They have a form online. You can fill out the form, and they say within 5 days they'll notify you if they could find it. I had no faith whatsoever of ever seeing this coat again, but this morning I got an email saying they found my coat. I can pick it up whenever I want. I don't have to tell my wife that I did something stupid. Anyway, I know many of you, and the one thing that mildly surprised me is that no one has made a comment to me that my appearance has changed. Nobody. I'm not talking about radical change, but I feel good about this because I feel good about technology. I don't want you to go through my presentation and think this person really doesn't like technology at all. What you are missing is, at least those of you who, I must know at least half of you, I don't wear glasses anymore. So I had what's called cataract surgery, kind of a minor surgery. The point is not simply to get rid of the glasses. Actually, my family doesn't like my look without glasses. But now I have to get glasses that have non-prescription, clear glass lenses just to satisfy them. But the point is, it makes it a lot easier to see distances. Not so easy to read anymore, but rather remarkable use of technology. Anyway, as indicated on the screen behind me, I'd like to talk about healthcare and the problems that arise with the modern system of healthcare and what I call a new ecosystem of public disputes. You saw this, if you were here this morning, you heard about the divorce technology software that, I forget his name, Darren. They called an ecosystem of divorce. An ecosystem mainly means that a complex network or interconnected system. And if you touch one part of the system, it has an impact on the other parts of the system. Disputes can go down or go up. Acceptance of technology can rise or decline. And it, I think, simply gives an easy framework for understanding some of the things I'm going to be talking about. I should mention that this is not, I confess really, that this is not not consistent with what the program says this should be about, namely a public body. In the United States, and this is about the United States, so I apologize to you who were not from the U.S., but in the U.S., healthcare is largely a private affair. Has some good parts, many bad parts, but it's not really something that the government, except in kind of extreme cases, is responsible for. But it does provide a lot of things that we can learn about healthcare because these ecosystems change as participants change, as the size and complexity of an ecosystem grows, disputes become more likely. Healthcare is a particularly large and complex ecosystem. And I think it is true that everything is magnified with the impact of technology. So what does the health ecosystem look like? Here's one attempt, which I'll get back to later. But it's a well-known physician and policymaker. Information is the lifeblood of modern medicine. Health information technology is destined to be its circulatory system. Does that seem right? I think so. Or at least partly right. As I say, I'll get back to it later. An example of the ecosystem. Well, this is part of the ecosystem. It's an ongoing dispute. Took this picture a few days ago. Healthcare workers. But the ecosystem is complex. So these healthcare workers, who are they? Well, there are a lot of people. How do you settle a dispute with so many participants in the ecosystem? It becomes more and more difficult. Simple disputes may have simple consequences. This kind of a dispute has large consequences. And it's not even touching on technology very much. So here's another piece of the ecosystem, a guy named Dr. YouTube. He's an actual doctor. He's a cardiologist, and he's the director of Google Health. And his goal, responsibility, is to deliver authoritative medical videos. Well, what can go wrong? Can anything go wrong? It's rather simple. All he does, I'm sure everyone here has found videos online, but if you're on Google trying to do this without disputes, not so easy. So you run into the whole problem of misinformation, and that's was immediately true here. And now he's faced with a lot of parties with additional conflicts. If you are interested in this particular topic, look up the YouTube medical misinformation policy. It's a lengthy policy statement. And Google's not the only one. The Mayo Clinic, a famous hospital in the US, has more than 1 million subscribers. And there's a medical social network called Patients Like Me. If you've got a medical problem and you'd like to find out more, but you don't trust your doctor, or you'd like information in addition to what the doctor tells you, and in addition to what Google may tell you, you can join this network called Patients Like Me, and you can contribute information about your illness or condition, and you can receive ideas from people who are suffering from the same condition. Here's another example, Dr. Amazon. Well, there is really is no Dr. Amazon. I made that up because it seemed to parallel Dr. YouTube, but this is a real kind of story because Dr. Amazon is interested in more than just videos. If you look at the screenshot or the graphic, it says One Medical, Amazon. Well, One Medical is a business that was purchased by Amazon. It looks like this. So Amazon is online, and it's got fancy primary care offices. Again, this is US-centric, so our system, if you're sick, generally go to what's called a primary care doctor. You may go to an urgent care doctor, but Amazon thinks it can attract people by having a nice-looking office. And one other thing, the cost is $200 a year for what's called a concierge doctor, concierge primary care doctor. The average cost is $3,000 a year. Concierge doctor means this isn't a person you have to wait online for. You have their cell phone number, you can call them up. They're available 24/7. It's kind of elevated kind of care. And Amazon bought them. So Amazon owns Amazon. It owns this concierge primary care office. And this primary care office has many elements. It provides value to patients, but it less noticeably provides a great deal of value to Amazon, since the goal here is, as I'm sure most of you know, data collection. And if you're wondering about that, well, more obviously is this third element of Amazon called Amazon Clinic. Amazon is a message away. Quickly treat common conditions with 24/7 video visits, messaging. So no physical entity, but this Google Clinic is available to you sitting here. If somebody has a headache or whatever, you've had too much caffeine, call up the clinic. Well, don't call them up, access them, and you can find it, conditions, almost any kind of condition. So this is a screenshot of some of the conditions you can find on Amazon Clinic. A screen goes on 2 or 3 times, so there are a lot of conditions that are available to you. Accessing them costs you $30, pretty cheap. But again, what's the point here? The point is Amazon's collecting data. And Amazon's not alone. Costco and Walmart, big websites are providing the same thing. I saw in yesterday's newspaper, Walgreens, a big pharmacy chain in the United States, is opening up something similar. Insurance company, just read about yesterday, an insurance company, name I don't remember, buying into one of these online services. The goal, of course, is to get people healthy, but also to monetize healthcare. And look at the bottom. What else is being provided to Amazon? Reducing time and burden of doctor's visits, delivering drugs, providing nutritious food for in-need patients through Whole Foods or Amazon Fresh. Amazon owns a high-end supermarket called Whole Foods in the U.S. Do they do business here?
Yes. Whole Foods is in Ontario.
Whatever. So you're going to buy a head of lettuce at Whole Foods. You're actually supplying the Amazon system. But there are some regulatory and legal challenges to this. Number one, HIPAA, which is the main protector of information and data in the U.S., does have a problem with Amherst Clinic. Amherst Clinic turns out, let me go back. These things are, Amazon doesn't own any of these things. Okay? Amazon has links to these and agreements with entities that supply these services, but Amazon doesn't own any of them. And the regulation of information use in the U.S. doesn't seem to regulate that. So if you sign up for Amherst Clinic, they can sell your data to whoever they want. The other big fault with regulation of the distribution of information in the U.S. are electronic health records. How many of you have seen your electronic health record? Nobody? 1. 2. A mild state of shock, but why am I in a state of shock? Because all of you, I'm sure, or 95% of you, I'm sure, have electronic health records replacing this. So, in the U.S. at least, increasingly this kind of office with lots of manila folders doesn't really exist. The electronic health record has a lot of valuable conditions to it. But one of them is that just imagine the difference between a paper record and an electronic record. Well, 95% of you don't have electronic health records, but you do have paper records. But the problem is if you all had electronic records, by law in the U.S., you'd have access to them. Here, actually, with these paper records, HIPAA requires that you have access, but nobody does. Nobody does, because who's going to go into a doctor's office and ask for a copy of their paper record, which you may have to pay money for? So we have a system in which the electronic health record is the center of data collection about individuals in the US. And as it turns out, it's full of misinformation. Usually when I give a talk like this and I ask how many of you have seen your electronic health record, a lot of people say yes, and I ask, have you found any errors? And almost inevitably, there are mistakes. My wife looked at hers and found that she had diabetes. Well, she didn't know she had diabetes, and as it turned out, she didn't have diabetes, but the record said she did. The bigger problem with all of this is that nothing stays in the record as it is. If something sent to the paper record stays as a paper record. The message, data sent to electronic health record gets merged with other health records. Basically, you end with a system with bad data. So I don't want to make fun of this. This is an incredibly serious issue, because the healthcare system is run on data, and if the data is bad, everything else falls apart. So wireless devices, well, wireless devices are regulated. Let me tempt myself to ask another question. How many of you have Fitbits or wearables? What's the matter with this group? Amy has all of it. Wearables, some of them are regulated by our Food and Drug Administration, some of them aren't. I'll ask another question. How many of you have Apple Watches? Well, that's good, in my mind anyway. But if you have an Apple Watch, you have it, its functions are regulated by our Food and Drug Administration. And they've approved Apple Watches, because Apple Watches can give you an electrocardiogram on the spot. So if you think you're having a heart attack and you have an Apple Watch, you're probably, I don't know how it's going to help you, but anyway. But if you have the kind of device that Amy probably also has, you have an Apple Watch?
No, I have a Fitbit.
Fitbit isn't regulated. So Fitbit doesn't regulate, but records, the amount of exercise she does. And I've got to finish this in 1 minute. So Michael took 10 minutes this morning. Let me have 2 more minutes. Lastly, a big, an AI problem. One of the electronic health record companies is called Epic. It's privately owned. It has about 2/3 of the market share in the US. And it provided an algorithm to detect which patients with sepsis, blood poisoning, which patients had sepsis and which didn't, which needed antibiotics or which didn't. And as it says here, I think it says here, its algorithm missed 2/3 of sepsis cases, rarely found cases medical staff did not notice, and frequently issued false alarm. So prediction of who has sepsis and needs antibiotics. They evaluated 96 components, assigning weights to different ones. In other words, a pretty complex algorithm with no real explanation of testing or what's in the algorithm. And they withdrew it from the market. but there are 512 approvals for AI and machine learning devices that have been approved by the Food and Drug Administration. Most of these involve radiology. So it's accepted fairly well. It's used frequently to diagnose diagnose conditions you don't want to find. And they've been accepted since it's been found that in many cases they work more effectively than radiologist's eyes. The challenge, of course, is devices that learn over time, maybe learning well, perhaps not learning it that well. So lastly, the quote I mentioned earlier, what happens for information is the lifeblood of modern medicine. Health information technology is destined to be its circulatory system. Well, is that exactly right? Or is health information technology destined to be its brain? Seems like, to me at least, more likely we end up with AI, we end up with some kind of brain regulating this system. In any event, thanks.